We're going to go ahead and get started. Thank you to everybody who's joining our webinar today. My name is Jody. I'm with SCORE. I am the Education and Events Manager. And I have Ashlee Gonzales with me today, who is an attorney with Brewer, Offord, and Pedersen. I believe you guys are out of Palo Alto.
Correct.
That's where the offices are located. She's going to give an update of all things legal COVID, updates on what we're hearing about contracts and different cases that may be coming through. We are recording this, so if you can't stay on the whole time, we'll go ahead and be able to send it out afterwards. And, you know, also check out score.com/calendar for any other classes and webinars we come up with. I'm sure as more information comes out, we may have Ashlee or someone else from the law firm come back and give even more updates, maybe as rulings start coming out, and we'll go from there. So Ashlee, finally, Q&A. If you have any questions, at the bottom of your screen, you'll see two things. You'll see a Q&A and you'll see a chat. If you can put any questions in the chat box, and then we'll be watching those as they come in, and as Ashlee's speaking, she'll kind of keep an eye on that and answer questions as they come in. And then if we have time at the end, maybe we'll do some hand raising, and we can take some live questions. So with that, Ashlee.
Thank you, Jody. As Jody mentioned, my name is Ashlee Gonzales, and I'm an attorney at Brewer, Offord, and Pedersen. I've been with them for about 5 years now. I took the bar in July 2015 and began practicing with them right away. So literally all I've done in the legal field is real estate. And I just want to talk to you guys today about what we've been seeing the last 3-4 weeks and even before that, and try to help you help your clients and also yourselves. And so I just want to talk about the listing agreement and purchase contract, along with how that ties into some of the landlord-tenant issues we're seeing, because it is relevant to transactions, and I'll get to more detail on that later on. And if you have questions, please put them in as I go. If I can address it during, I will. If not, you can pick my brain after, just whatever your preference is. If you want to hear me out and then ask your question, that's fine too. So just to get started, the virus itself has not caused a huge change in the legal field, so to speak. While it has caused a major disruption in real estate, the legal components are generally the same. If you were around practicing real estate in 9/11 or the 2009 crisis, which I admittedly for both, I was not an attorney yet, but I heard about it and I've seen relevant cases that I think we can talk about. But if you were around during those eras, so to speak, you saw effects on the transaction, and it changed the way that buyers and sellers performed or not performed, depending on, you know, what the situation brought up. But generally, the legal landscape has not changed. The only downside to what's going on and we're really struggling with is that there are no rulings yet. There hasn't been a judge that has said, okay, this is an excuse to back out of the contract or what have you. Number one, because it's so new, it's been less than a month since the moratorium has been in place, or the shelter in place order. And number two, the courts are closed. I have several ongoing cases, evictions, partition actions, those types of things where they've been put on pause completely. And if you have a new case, deposit dispute or whatever related to the transaction you might have, it's very difficult to get that going right now, if at all, depending on the county. So to jump right into it, for the listing agreement, number one, I think that is most important to start with. While we don't see as many cases coming in regarding this, we have received calls from clients and brokers. Essentially, we get calls from clients and they call us up and they say, hey, due to the changing landscape of how real estate is conducted, particularly Santa Clara County, I want to back out of my listing agreement. And they ask us, do I have any options? What can I do? And, you know, unfortunately for agents, the answer is usually they may have a way out. And there's several causes for that. But number one, you may have heard about the force majeure clause or the act of God occurrence. And essentially what that means is that when the contract, it could be a purchase contract, listing agreement, rental contract, if it's impossible to perform due to an intervening act of God, typically that'll allow the affected party to back out. And so what's happening is clients entered into a listing agreement with their agent, and some of them say, okay, we will get a $5 million sale price, $2 million sale price, or whatever the terms are. And now that there's a shelter in place order and a bunch of regulations and the market's suffering, the clients have an argument that, hey, this contract is impossible to perform and I want out. And more than likely, we think a judge will agree. While we haven't gotten there and we haven't even gotten to mediation, just because that's a whole nother logistics problem. You know, we can't meet in person. It has to be virtual, likely on Zoom. That's probably the number one issue coming up with listing agreements. And many of you have probably seen the new CAR form that's been introduced. It's the RLA CAA. It's a listing agreement coronavirus addendum. And this was introduced by CAR, admittedly in a rush because they were trying to help out agents to either provide to their clients as an amendment to the existing listing agreement they have, or as an addendum to their existing listing agreement before they enter into a contract with the client. And, you know, the form tries to provide terms that only virtual showings are allowed, or one person in the property at a time. The one downside of the form is it's a statewide created form, and it doesn't have specifics on there for each county. For example, with Santa Clara County, in-person showings are only allowed if a virtual showing is not possible, and the form doesn't address that. And so by nature, the form requires some kind of customization by agents, which admittedly is nearly impossible to do because yes, you guys pass the broker's exam or the salesperson's exam, but unless you've gone to law school and you've been taught how to do legal writing, you're kind of creating landmines for yourself. And the county's forcing you to do that by their shelter in place order and the essential services regulations. But, you know, if you really want to have a really nailed down listing agreement with everything going on, I would suggest you seek counsel. We've been doing that. We've been drafting custom addendums to attach to the CAR listing agreement addendum. I know it seems a little bit tedious, but truly when a dispute arises, you're going to want protections in there for you. And I'd recommend you seek our help, just because the form is a one-size-fit-all form and it doesn't really meet the specific guidelines per county, per city. Santa Clara County is particularly strict just because we've had so many cases of the virus, and they're really taking every precaution to protect sellers, buyers, and agents. Again, if you have a new listing, we recommend you do use the addendum, but also with custom language. But for existing listing agreements, I think that's where most of the disputes come down. You need to keep an open line of communication with your clients. And what does this mean? So what I've seen happening in most of the complaints we get, and most of the complaints that when lawyers get in trouble get, is a lack of communication. So understandably, I think it was March 16th, I remember I was in the office and all this kind of hit at once. You know, the governor was on TV. They started instituting all these rules. We couldn't go in the office. And you know, one couldn't fault you if you hadn't gotten in touch with your client for, say, a week, 2 weeks. But if you put yourself in that seller client's position, you know, all this is going on. They haven't heard from their agent. They have a listing agreement. Certain things are supposed to happen. The property is supposed to be marketed a certain way. And if they haven't heard from you, that's when they start calling us and saying, hey, I want out of this agreement. I haven't heard from my agent. I don't know what's going on. I don't think he can perform. But a good way to solve that is to just call up your client and say, hey, this is what the rules are. I think we can work around it. The county provides us as an essential service, but that comes with limits. This is what I can do. This is how we can get the best price, all of that. So I think there's a solution to preventing clients from wanting to back out. And I think that's customer service. I think that's with any industry. Same with us. We're having to work with clients in the unusual way right now via Zoom. A lot of clients like in-person meetings, but we're just having to go the extra mile to make sure they're satisfied. And I think that will go a long way with your clients when they don't feel like they're getting the value of what they contracted for. So those are the main issues with the listing agreement. And a good thing to tell your client, and that's in the addendum form, which I think that it may not serve your interest right now, is to go on a hiatus. Essentially what the form says is that, hey, we could put this on pause. We could put the agreement on pause until everything calms down. And then say if it's for 3 months or 4 months, hopefully, you know, this all calms down by then, we'll see. And that time just gets added on at the end. So if you pause it from April to July and your listing agreement was supposed to end in October, now it can end in January. It saves you the stress of having to conduct business during rather difficult conditions. And then the client knows that once everything settles down, you're there for them and they still are in contract to get hopefully the price they wanted and everything else. So there's options in there. And while a hiatus might not be great for you because, yeah, you're working and you need to be paid, you need the commission because that's your livelihood. You have to pay bills. We're all under the financial stress right now. But you just have to think about, would you rather lose the client or extend the listing agreement? So that, to me, that's the most viable option with the listing agreement, is go on a hiatus. But if you want to discuss that more, just let me know. Okay, perfect. Next, we'll jump into the crux of the presentation. It's the purchase and sale agreement. This, by and large, we've received the most calls about, both new build contracts, residential properties, all over the map, and also commercial properties, which I'll talk about later on because that had a landlord-tenant aspect included in that. But primarily, we're getting a lot of buyers calling and saying, hey, I can't do this, I can't do that, I can't get lending, the lender is taking forever to approve my loan, I want to back out of the contract, or hey, I wasn't able to perform and the seller canceled, I want my deposit back, can I get it back? And so, I mean, that's the primary call we get, and the lawyer answer to all their questions is, unfortunately, it depends, and it's very fact specific. But I can give you a couple examples. Number one, we had a buyer called in and he had entered into a new build contract, and it was about 2 weeks before this all went down, and all of a sudden the pandemic took over. He lost his job. His wife is a teacher and they don't offer virtual instruction, so she's essentially out of work as well. And so they don't want to commit to entering into this huge loan for a new property, and they want it out and they wanted their deposit back. You know, obviously my initial advice was like, this doesn't look great. While we do think you have arguments due to the pandemic and your financial effect, it's difficult to get the deposit back in those instances. But what I've seen happening a lot is that sellers kind of see the writing on the wall and they know it's an unpredictable outcome as well. And they actually cut the buyer loose and gave him his deposit back just to avoid the fight. A lot of times, especially with the new builders, they have another buyer or a backup buyer lined up, or they think they can get one pretty easily. And instead of playing tug of war with the existing buyer over 30, 40, 50 grand deposit, I have seen more likelihood of that being released than normal. I don't know if it's just because of the circumstances or they have empathy for what people are going through, but it's not a hopeless cause by any means for buyers. And so if you do have a client in that situation, it may be fruitful to call us. Also, another element that I've had to balance for my clients is the economic ratio. So if they're, for example, if you're in contract to buy a $1.5 million home, and just say your deposit is 80 grand. If you were to back out and even lose that deposit, there is an economic analysis to do here, and I'm not qualified to do that with any certainty, but there's a possibility that $1.5 million property can drop more than the 80 grand deposit. So say if they were to back out give up their deposit, and in 3 months, and the economy is struggling and everything like that, and the property is listed at 1.1 or 1 million, then maybe it was a good economic choice for the buyer, and they actually can get a deal on a different property due to the market going down. Again, that's all speculation, and I can't tell you that that's for sure going to happen, but it may be something for buyers to consider, that, hey, yes, I'm giving up my deposit now if they don't have a way to get it back. But I may be in a better position to buy in a few months because the market might change or the bubble might burst. We don't know. But that's just something to, as a representative of your client, to say to them, like, hey, you might want to consider this. And again, I hope the market doesn't go down, but it's definitely a possibility, and I see that happening just because of everything going on and unemployment rates and all that. So that's that element. And then as the counter side, if we represent the sellers, and we have, there's the act of God clause and then the act of government. So for force majeure to take place, it has to be a superhuman intervening act. And this can be earthquake, the virus we think applies. 9/11 was an instance where people were able to argue it. But then there's a counter argument with act of government. And what I mean by that is a lot of sellers are arguing, no, you shouldn't be able to back out and get your deposit because it was the government's intervention that caused the inability to perform and not the virus. So it's an argument saying, you know, what actually caused the disruption? Did the lending not get approved because of the statewide shelter-in-place order or all of these things? The stimulus package, we don't know. The counter argument to the buyers is that it's an act of government, not an act of God. And so that's an interesting thing that we think will play out. And really, you know, if you've ever been in court and you've been in front of a judge, you'll see that a lot of times they do split the baby, and they give an equitable result where it's kind of a middle ground. But I think in this instance, they may have to make a decision one way or the other and make the determination if this is an act of God or act of government. And so that's yet to be seen. Another example, a case we just had come in recently this week, we had buyer clients call us and they wanted to back out and get their deposit back. And they entered into contract beginning of March. And what happened was their lender's office had to scale down their business due to the shelter-in-place order, where they can only have one person working at a time. And what this did was it didn't prevent them from getting funding, but it slowed their approval process down to the point where the seller sent a demand to close escrow. The buyers couldn't close because the lending was taking too long. And then they sent a cancellation, you know, within the exact amount of time. And so we're arguing that it's not the buyer's fault. It's the virus that's caused the lender to have all these delays. And, you know, this is a excuse to non-performance. While yes, the sellers can say, hey, buyers, you didn't perform. I sent the notices per the contract, and, you know, liquidated damages applies. Well, no, not always. And so what happens is we're arguing that, and then I'll get to it a little bit later, but another way that the buyer can get their deposit back is if they invalidate the liquidated damages provision. And what that requires essentially in this instance, in Civil Code Section 1675, is you have to have the intervening act or something that the buyers had no control over. And then you have to watch the property for 6 months after. And if it was resold for the same or a higher price, arguably the sellers were not damaged and the clause is invalidated. But we'll hash that out a little bit more. But some of the main reasons why I've seen buyers not be able to perform is the funding issue, the lenders having delays, repairs can't be completed as agreed to. So, you know, they're trying to get a plumber right now or a mold inspector is very difficult. A lot of them don't want to go out. I see a lot of them still conducting business, but it's questionable if they are essential, how to conduct their business. Do they have to sell or leave, or how to do that? Also appraisals, same issue. And then the issue of moving into the property. So per the contract, the typical language is that the seller has to vacate and give possession to the buyer. Now, especially in the county of Santa Clara, but statewide, there's an eviction moratorium. And this just doesn't apply to just tenants. This also applies to sellers, unfortunately. So what happens is they're getting ready to close escrow or whatever the case may be, where the seller has to vacate. And for one reason or another, maybe the seller has nowhere to go. They couldn't buy their second property because of COVID-19, or they don't want to move during a pandemic, what have you. It's impossible to get someone out right now. Even for pending evictions I've had that were based on reasons before the virus, complete standstill. You can't get rid of possession. You can't get the sheriff out there, nothing. And they've even been pretty strict about serving notices, and that's for non-payment of rent and no-fault evictions. For instance, in the county of San Mateo, if you serve a notice invalidly that violates the moratorium, you could be liable for money damages, emotional distress damages, attorney's fees, and what they call treble damages, which means you can get triple the amount of the total damages. And so they are not playing around, to put it lightly. And if you think about it, if the seller really wanted to, put up shop and stay in the property and not move out, this is a huge problem. And I see a question on the side here I might be able to address right away. Again, this isn't, I can't answer it for your specific property without knowing where it is and what county, city. Most of them are 120 days where the tenant has to pay the rent back after the moratorium is lifted. Some 180 days, San Jose. Okay. So this question is twofold. And the question was, how long is the period of restriction on evictions? And really, number one, we don't know. As of right now, I believe it's May 13th, but given the way things are going, that's likely going to be extended. I think Jody mentioned she saw something from Governor Newsom today saying, summer's coming up and people are going to want to gather and do all these things, and he just doesn't see it happening. Same thing with evictions. And then the second problem with that is that the courts are closed and who knows when they're going to open. And a major problem, I'll talk about this more later, is that even when you do file before the virus, it took 18 months to 2 years for a civil matter to go through to trial. An eviction, anywhere from 45 days to 60 days to finish it. So just imagine when the courts do open back up, there's going to be a huge backlog of the existing cases that need to be heard that have been put on hold and people have had to wait to have their matter heard. And then all the people that are just waiting at the door, essentially trying to get in to file their action, it's going to be a complete mess. And so when you can get someone out, I wish I knew. And I handle most of our landlord tenant matters at the firm, if not all of them. And so that's kind of my niche. And I feel handcuffed right now, definitely. And it's frustrating. I've had clients call and that want to evict their tenant and they have a totally justifiable cause. I think there's no issue with it. For instance, this woman wanted to move in her children into her home that has a tenant because they don't have anywhere to live right now. They were living like in a joint housing, a communal housing environment, and she doesn't want them in that. And we're pretty hesitant on even serving notice on a tenant right now, because if they get a tenant lawyer that is fired up and they want to go after the emotional distress and all those damages, it's going to be a tough fight. And so that was a long-winded answer to you, Jeff, but the answer is I don't know as of right now, and there's not much we can do. I think step one, at least, would be to talk to us and see if we can serve notice, because the one thing you should do, if you can, is get that notice period started. So if they're entitled to 60-day notice, we might want to start that notice period. So if the courts do open in 60 days, you're ready to go. But right, I'll get back on track. I just thought that was an important issue to address right now. And I had another question about the case I was talking about. Did the buyer have contingencies? In the case where they couldn't get lending in time. There's no contingencies. There's no loan contingency, but we still think they have a way out because of the contractual law, the force majeure clause that says if it's impossible to perform, they should be excused from performing and thus should get their deposit back since they're not at fault. But yeah, there was no contingencies in that case. And that's usually the case with most contracts that we see in the Bay Area, at least, is no contingencies, either all cash or predominantly cash. So let's move on just a bit. And then even more than, I would say, inability to perform, honestly, a huge chunk of the cases coming in is unwillingness to perform. What's happening is buyers entered into contract, they were excited about a property, and I'll pay whatever. I know it's a competitive market. Let's offer this amount. No issue. And then all this starts going on. They either lose their job, they anticipate the market going down, something causes some effect where they don't want to close. And, I totally respect that. I understand that. I personally have not bought property yet. I want to. We've been saving, but I don't feel very comfortable right now. We don't know what the market's going to do. And who knows if you enter into a contract now, are you going to be overpaying? And so that's a huge issue that we see going on. But again, we kind of reiterate the economic ratio to them and say, okay, look, is you backing out going to save you money in the long run? Because the property value is going to drop more than what you will lose with a deposit. And if the answer is yes, you may just want to cut your losses and back out. And so that's one thing. But even the cases that look the most dim from the onset, and they call us and we hash it out and we really get down to the nitty gritty of the facts, I've seen some cases pan out where I didn't think they may have had a reason to back out initially. But after a review, we're like, oh, wait, I think this one little fact or email does give you the ability to back out. And so I would give us a call regardless, or have your buyer clients give us a call if they really don't want to go through with the contract, because this is a multi-million-dollar or million-dollar property that they're buying. And I would seek some counsel before they go forward if they have hesitation. Again, just to talk about the CVA form a little bit, this is the coronavirus addendum form that they came out with. If you've been following this pretty closely, you will know that they came out with an initial form. It was done like the other listing agreement addendum pretty quickly. I think they just wanted to address our needs as fast as possible. But the form's been revised a little bit, and if you have zip forms, you could see that pretty easily. Most of us at the firm have our broker's license, so we do have access to those forms, and I've had a chance to use them and also advise on them. Like the listing agreement form, however, we think it is a one-size-fit-all form and doesn't address certain specifications of counties and cities, and so you need to be wary of that. But what Carr said about the form was, since the purchase contract doesn't have a force majeure clause in it, they wanted to fill that gap and explain what it is and provide that to buyers and sellers. And again, there's arguments there that even though it's not in the contract, it is a contractual law and it applies, but nonetheless, they wanted to fill that gap for people, since this is the number one question coming up, is the virus an act of God, and does it excuse me from performing? Again, the form is also connected to another form, and that's the notice of unforeseen circumstances, and they're connected. So, and that cancels either the extension, or that either extends the agreement or acts as a cancellation of the agreement. So while this form may be helpful, we do have some gripes with it. I think that's just the lawyer perspective. We always are going to be critical of the forms they put out, because our job is to protect you and the buyers and sellers. And so we rarely take the form at face value. And so we have assessed it just to give you some feedback on issues that we see with using it and the holes, so to speak. First, if you are already in contract, this form is not mandatory. And so we've seen issues with buyers and sellers not wanting to sign the form, even though it is fairly helpful, because they think it's just going to give the other side a reason to back out. In some ways, they're right. But number one, we've seen an unwillingness to sign this form once they're already in contract. And there might be alternative ways to address the issues presented by the virus other than this template form. And we can talk about that for hours, but generally a good amendment or an addendum to a contract drafted with legal language specific to the transaction itself and the issues presented could go a long way. For example, my buyer clients that had problems with their loan, had the seller called us or the buyer called us right away, we would have said, hey, let's just draft an addendum that the parties understand that the delay is at the fault of the lender and not the buyers. And as soon as lending is approved, the buyers hereby agree to close escrow. And that way the sellers know, okay, the buyers are serious and they're putting in writing what the issue was. And arguably it protects the buyers later on, but I'm biased since I represent them. But that is, the form doesn't provide for that type of thing. It doesn't provide for the specific issues coming up. It just tries to generalize them, which may be good if you do fit into those criteria. But again, you want to be very fact specific with your forms when you can. Other shortcomings that I really have an issue with, and even though if I look at it from the bride side, it could benefit me greatly, is that the cancellation section of that addendum does not provide the type of release that I would like and that I like to put for my clients, and I'll explain. I'm sure you've seen the cancellation of contract form, and it has a release in the bottom. Regardless of how you cancel, if you cancel and keep the deposit in escrow, or you release the deposit to one side or the other, it has a release in there saying that the parties hereby release each other from claims arising out of the agreement or what have you. The problem with the car COVID addendum is it does not have that type of robust release. And so what you can run into is the parties can agree to cancel the contract right now, but in argument, they haven't waived their ability to sue the other side. And so, yeah, they can give the deposit to the buyer and then in 3, 4, 5 months, send a mediation demand or whatever they want to do. And this whole litigation picks up. And, you know, I see that as a major issue. And while it provides me with more work, understandably, I don't like that for buyers and sellers. When they sign that cancellation, I want them to be done. I want them to have peace of mind that them signing it acts as, okay, I'm out of this contract for good, and they're not going to be served with a summons or a mediation demand later on. So that's one major problem with the form. I see some questions. Let me see if I can address any of them right now. So I have a question, how long we should use the form. My gut reaction without doing much research on that, Jaime, is that you should use it until the regulations on you as an agent are lifted. I think that's the most clear-cut answer. So once the regulations put on you as an essential service, this means, you know, the virtual showings regulations, all these things where social distancing, that type of thing, once that is lifted, I think we can get away from that, because the main causes of why the form is necessary is because of the effects of the order and social distancing requirements. Because, you know, just for example, go back to the lender, they can only have one person out in the office at a time, and so that caused significant delays with loan approval, things like that. So once the real estate industry has those restrictions lifted, I think you can go away from the form. But again, just as a general rule of thumb, I don't know if the form is sufficient, and that was asked before, just because of the release and the general lack of specificity, where it might not address your issue exactly. And the last thing you want in a contract, which you may all know, is ambiguity. If there's not a meeting of the minds in that form, that addendum form, you may have an issue that there was even an agreement regarding that in the first place. So you want to be very specific to the case at hand. Let me see any other questions. I have another question about landlord-tenant issues from Jaime, and that reminds me of another issue, and this is not related to buyers backing out or sellers wanting to keep the deposit. This is a disclosure issue. What I've seen coming in only once or twice is that we've had buyers come to us and are basically complaining that the seller didn't disclose that the tenant made a complaint to them that they couldn't pay rent due to the virus. So what happens is if you don't pay rent in, arguably now it's statewide, in an area where there's a moratorium, the landlord could serve you with a 3-day notice to pay rent with usually accompanying documents. And what the tenant has to do is provide documentation of why they can't pay rent. It's not just this automatic postponement. And what happens is the landlord will get documentation saying, hey, this is my paycheck before the virus, this is my paycheck after, this is why I need a rent reduction or I can't pay rent right now. As a seller, you really need to provide that to the buyer. And you have typically the tenant estoppel certificate, but that only goes so far. If you have knowledge that the tenant may not be paying rent for 4, 5, 6 months or even more, you need to disclose that. And that goes for commercial tenants as well if you're selling a commercial property, because I've had commercial clients come to us and just for example, the County of Santa Clara's moratorium includes commercial businesses of, it's called small business, and that means if you make less than $8 million a year in profit, which would be a lot of businesses in Santa Clara County. But if they can't pay rent due to a financial effect from the virus, they can have a postponement. And so just knowing that and knowing that you should disclose all that information to prospective buyers, I think that's very important, because if the buyer gets in there and either thinks they can get the tenant out or thinks that the tenant has been paying rent, that's going to blow up into a major dispute. And as many of you know, disclosure lawsuits are the most expensive by far. They sue you as the agent almost every time because you have insurance. And so you will get dragged into that. And so make sure you tell your clients to disclose that. Let me see. Okay, so I talked about some downsides of the form. It doesn't have the robust release that I would typically like, and it may not be specific to your needs. But what about when there's instances where there's no addendum being used, one side won't agree? What do you do? And this is my general advice with any dispute regarding the contract, is to work it out. And it's even more relevant now. Number one, you can't bring an action to the court right now to sue the other side for the deposit or anything like that, just because they're at a complete standstill. I think they're hearing ongoing felony cases of civil harassment and very few others in Santa Clara County that I'm aware of. And so, taking this stance that if you're in a dispute with the buyer or seller, and if you've tried to do mediation, you sent your mediation demand, and you want to sue them, that's not really the answer right now. While you do have an ability to do that, your case will not be heard for a long time. And so the parties are encouraged to work this out and come to an agreement. Just because of the delays and the cost of litigation on top of that, I would say our number one advice is we need to come to some kind of an agreement. And then just to piggyback on that, on the cancellation form, if you do work something out with the other side, please call us. I know it's self-serving to say that, but very seldomly have I done a cancellation for a client and have not added language to it. I've never, ever had a client sign the form as is, even the non-COVID form. So if that tells you anything, and that could be just a simple language, even the release and the cancellation, at least to my preferences, is not enough. And so, and spending a little time with us just to get our advice to make sure you're doing everything right and protecting your client can go a long way. So I would say, number one, have us review or help you draft the cancellation form. And in the perfect world, if you have the time and the finances, is to have us draft a settlement agreement. Basically what that does is it describes who's doing what for who and puts in our typical release that we like in very robust language, and also create some protections that should one side not perform, you've already taken the first step towards filing in court. And so I would definitely recommend that. We've done that several times already. So if you need help with that, let me know. I would say that's the belts and suspenders method, in my opinion, is to have not only the cancellation, but also a settlement agreement. Next, I just want to touch on liquidated damages. So with that, I think many of you know and may have heard me talk about Civil Code Section 1675. If you haven't read this one, write it down. It's Civil Code Section 1675. And this covers liquidated damages. And so even if you have a buyer that has no arguments, no excuse to non-performance, and they back out, what this says for residential properties 1 to 4 units, you can monitor the property's behavior for 6 months after you cancel the contract. And what does this mean? Essentially, if the seller goes within 6 months and sells the property for the same price or more, arguably they're not damaged, and you may have an argument to the deposit. And so that's why I say, don't give up all hope right away just because your buyer client doesn't have an excuse to back out and get their deposit back. There may be recourse down the line. And especially since things are kind of on hold right now, waiting might not be that bad. So what I would recommend is you keep the deposit in escrow until the dispute resolves. And what that means is that you're going to monitor the property. I would be wary, though. There's some provisions in the code section that provide penalties if you withhold a deposit unethically. But if you truly do have an argument or a cause to withhold a deposit in escrow and not give it back to the seller, or give it to the seller, excuse me, I would say you go that route. But again, if you're in this situation, I would say call me because it's very fact specific. But even at the end of the day, you may have recourse for that deposit. And I think that's what buyers are really hunting for right now, is to get that money back. Let me see what else we have. If not, we can move on to some questions. Again, I wanted to note that selling a property with a tenant in there, or even the seller in there, is a major issue right now, just because there's no evictions going on. So if your buyer client thinks that they can move on the tenant and get them out, or collect the rent that they said that they have entered into contract to pay, that might not be the case. Technically, if the tenant has been affected, they can say, no, I'm not going to pay rent for the duration of the moratorium. And while they can get a postponement on that rent payment, it's not forgiveness. If you want to think about it that way, it's a rent forbearance. All of these moratoriums, the one commonality that they have is that rent will be due eventually if your buyer client can wait. It's just not due either during the moratorium and then for a set duration afterwards, either if it's 90, 120, 180 days. It just depends on your jurisdiction. But just make sure your buyer clients are aware of that, because it is a complete cluster right now with evictions. I'm typically willing to pursue any eviction that comes in and help a client achieve that. But right now, there's not a lot I can tell them. Initially, Gavin Newsom said, hey, local jurisdictions can make whatever rules they want regarding evictions, but recently he did the statewide one. So now pretty much everyone has protections in some way or another. Um, and just to touch on that landlord-tenant issue a little bit before I go to question and answers, one thing to know, and I recommend you seek our advice, is that there's city moratoriums, county moratoriums, and then a statewide moratorium. And you're probably wondering, what in the heck, which one applies to my property? And typically the answer to that means that whichever one is more protective of the tenants is the moratorium that prevails. So for this commercial client I had, they're in the city of Santa Clara and couldn't pay rent for whatever reason due to loss of profit due to the virus. And, you know, looking at the city of Santa Clara moratorium, I'm like, crap, commercial tenants aren't included in this moratorium. And what I did was I expanded to the county of Santa Clara, and there's actually a provision in the county moratorium that says commercial businesses are included if they can't pay rent due to the virus. And so I just thought that was an interesting note to make, because if you're trying to help out your client buy a property where they have tenants in there, you're a property manager, be careful with what you're doing with those notices and the leases, because while you might think that they're not protected because you looked at the city ordinance, you might not be correct, because if the state or county moratorium is more protective, you may run afoul of those ordinances if you do serve notice. And so that, and as I described, the penalties for violating those ordinances are super steep. I think most people in our firm and people I've talked to, you know, treble damages, emotional distress, that's typically unheard of, all in the same case. So they're really taking this seriously, and you really need to be careful, because it can be very costly for landlords and property managers. So if people have questions, I know that was a pretty quick overview. I'm trying to think of any other issues that we have had. Obviously, you guys are probably aware of the mortgage issues that have come up, and a lot of the forbearance that's been offered by state banks, also nationwide. So that has an effect on homeowners as well, and sellers and buyers. So it's complicated if you enter into a loan right now after the pandemic started. Some lenders are saying, no, we're only offering forbearance if you had the loan existing before the shelter-in-place order went into an effect. So it's a good idea to ask those questions on that. Also, the MLS listing rules have been relaxed slightly, but make sure you're abiding by those. If you do the hiatus that's provided for in the listing agreement addendum for COVID-19, make sure you're still abiding by the MLS. So while the form may say, okay, we're taking this property off the market, or we're just going to put it on hold, or what have you, make sure you're also abiding by their rules, because while you may make the client happy, you don't want to run afoul of the MLS. Last thing that I've seen come up is discrimination. Whether it be you're only asking certain prospective buyers about their symptoms or things like that. Whatever you do when you're conducting your essential business as an agent, you have to have a universal system. And what I mean by that is have a common course for everything that you do. So if every potential buyer contacts you, you ask them the same set of questions, you know. Unfortunately, I've seen some racial bias with the virus, unfortunately, maybe fueled by our government and what have you. And I've heard some agents doing the same. And so if they have a particular buyer call in and say if they're Chinese, they would ask, okay, where have you been? Have you had symptoms? Blah, blah, blah. If for example, a white client calls, you need to ask them the same things. You can't discriminate in those regards. And I doubt many of you are doing that just because it just doesn't use common sense. But I thought I would mention it because that would be a lawsuit likely against the agent for discrimination. And then that's something that you don't want to do, especially with everything going on and what people are dealing with. And so that's just a little wrinkle I've seen come up you may not think about. And you should really do in general is have a common course of conduct, because I've said this a million times in presentations, and Jody might have heard it before, is in a deposition, if I'm deposing you as an agent, I'm going to ask, okay, for example, with disclosure cases, did you review the disclosures with your client? And if you can't answer me in a way where you have a systematic way of doing things as an agent, you're going to get picked apart, and you're going to be questioned on whether you met your fiduciary duty. And a good way to avoid that is to have a set way and a set standard of doing things. So just to wrap that up, I think that agents right now are put in a particularly difficult scenario. We're having to conduct business virtually. A lot of people are old school. They like the handshake. They like to meet people in person, go over the forms, disclosures in person. And so I think this is definitely a brand new environment, but I think with some due diligence and research, we can get through it for sure. So let's see, if you guys have questions, you may want to send them in right now.
Ashlee, in the Q&A part, we've got several.
Okay.
Some of them may not be contract related. This may be a little bit of a different shift, but some of them have to do with the forms that businesses have to fill out, and asking if that's related to, like, do they post that on the door? Do they carry it? And then there's a question about what's a vacant home? And I guess agents may be bending the rules a little bit and telling the current homeowners to leave for a few hours, and then it's vacant, but
right.
Is it vacant? So what kind of guidelines do you have around that?
Give me just 1 minute. I'm looking right now.
And I will say this while Ashlee's looking at that. If you go to score.com/transaction, and I will put that in the chat box here, the question about the social distancing protocol in the Appendix A, our government affairs director, Tim Bobian, actually did a really good job walking through that exact form and how to fill that out as a real estate agent, because it's very difficult, and some of the questions relate more to if you're a restaurant or a place of business, but he walks through how to do that as a real estate agent. So you can check out score.com/transaction. And I'll just give some breaking news that just got released. Photography is now an essential service as it relates to real estate in Santa Clara County. So we know that the surrounding counties did approve that, but it is now essential in Santa Clara County as well.
Right. So I see the question regarding social distancing protocol. And as a lawyer, and I would answer this in many medias as possible. So number one, if you have a sign on the property, a for sale sign, typically they have a box with a flyer or what have you, put it in there. Anywhere where prospective buyers may see the property in person, which that has its issues, I would put it on your MLS listing as just as part of the disclosure, saying, hey, look, this is what the rules are in this particular area. This is what we're limited to do. So buyers are completely informed and it's been disclosed, so to speak. I would put it in every avenue that you can, even on your website. We have a portion on our website that says, hey, we understand what's going on. We have the ability to meet virtually. We're not doing in-person meetings, all of that. I would say, if you can say you put it in every area that you feel that people are seeing the property, and that's by way of your profile at the property itself, do all of that if you can. Just have a flyer, have the form itself filled out, and I think you'll be okay in that respect. I have an interesting question here. We have a tenant who passed away, and the son came out of jail and had a key and moved into the unit. What can we do about this? Well, obviously, he is not a valid, I wouldn't say a valid tenant, because it depends how long he's been there. Regardless of the situation, I have had squatter evictions. I've had people that, if they stay in the property a certain amount of time, sometimes they develop tenant rights. And so, while the notice requirements change depending on what kind of tenancy they have, more than likely you would have to evict them. This is an interesting one because you may want to call the police initially because you might be able to get away with a trespass claim, depending on how long he's been there. But number one, you want to call the police because you want to get that report on file, because when you are able to file an eviction action, if you have to, you want a paper trail. And so step one would be to get that police report and report that he did technically break into the home. I'm not a criminal lawyer, but there are arguments that could be made that it's still breaking and entering because he didn't have permission to enter. He did have a key, and we don't know what his mom told him before she died, so that's a little complicated. But step one, depending on how long he's been there, regardless, I would call the police and get that on record. They may just tell you, hey, this is a civil matter. That's their typical response to this type of thing. That's okay. Just try to document their response to it and that you acknowledge that he's in there without permission. And then, you're probably going to have to evict them or do some kind of proceeding. You're not going to have to serve a 60-day notice. I would almost guarantee that if he hasn't contributed any rent. But again, he still likely has some tenant rights, and so you want to be careful. But I would say step one is to get that report done and then call me, at least to point you in the right direction, or we can get notice served or what have you. We can figure that out, definitely. Let's see.
And I'll just jump in. We're just about to 2:30. And I will just make this statement. If you're able to stay on and hear the questions, Ashlee, if you're able to stay on a little bit more and answer some more questions, then I'll keep the webinar open. Thank you to those who were able to join. That's awesome. And it looks like we'll have Ashlee again in the near future. So I'll let Ashlee keep asking questions, and for those of you that want to keep watching.
So I see a question too, how vacant is a vacant home if it's been shown 7 times today? That sounds like a riddle, which this environment creates by nature, admittedly. I haven't researched this a ton on what has been defined as vacant in the essential services guidelines. CJ, if you want to email me directly, I could poke around for you if you want. I think someone else asked for my contact info as well. My email is my first name. It's Ashlee, ASHLEE, and it's at brewerfirm.com, BREWERFIRM.com. So it's Ashlee at brewerfirm.com. And I think Jody can send that to you as well. Also on our website. Let me see if I can. It looks like I could type it to you as well. I'll do that. Okay.
I was just doing that.
Perfect. Okay. So let me go through a couple more. So it looks like we have a question. Seller accepts a contract via DocuSign in the middle of January. While in China, this is common. The seller, due to the coronavirus, is quarantined and cannot sign off on the documents. Close of escrow is extended and they still have no date certain. Is this a failure to disclose the sellers in a quarantine in China? This one's difficult because, it depends when the quarantine went into effect. Did the seller know about this before they entered into the contract? And there's also a provision in the civil code that provides for if a disclosure is made and arguably needs to be made like this, that does open up the door for the buyer to back out. I believe it's typically 3 days, sometimes 5, depending on how that disclosure is delivered. But it really depends on when they went into quarantine, so I need more information on that. But this looks like more along the lines of an impossibility defense. If a party cannot perform, that is more in line with force majeure, as my buyer clients couldn't get lending, it was impossible to perform. And so if it's truly an issue with their ability to sign off and it's not something that they don't want to perform or they just don't feel comfortable, they may have the ability to either back out if they don't want to sell it anymore or get that extension. That's a little bit of a complicated one, I think, just because of what's going on in China. Just as a general matter, I think it's pretty unclear, at least from my standpoint, what's allowed and what isn't. I have clients there that I've drafted deeds for them and they can't get to a notary at the embassy because everything is locked down. So if they had a contract to sign those deeds, for example, I think we would be able to get out of it because of the impossibility defense. They have no way of executing them. And they certainly can't come here from my understanding. So yeah, it seems like more of an impossibility issue than it would be disclosure, but it would depend on when they knew about that issue. I have my listing, let's see. Okay, in regards to the notice, is it on our person, in the car, in the office, or again, as I mentioned before, I would do it in as many avenues as possible. Have it on your website. Do have it on your person when necessary. Post it on the MLS. I think that's the major one because that's what a lot of people are looking at, a lot of the agents. Even though they should be aware of those regulations, I would just say try to pepper that out in any area that your property is being shown. I know a lot of people do Instagram postings about properties that are coming up or that are listed. It may even be fruitful to put it in the caption there, say, look, this is property address, the listing price, just for prospective buyers' knowledge, there's social distancing rules that we have to abide by. Please call me if you have any questions. Also check out so-and-so website if you want more information. No one's going to fault you for over disclosure. And so I would say disclose, as we always do. I would just say to try to put it out there as much as possible, if that makes sense to you, CJ. Let's see.
And one of the things that I have heard is for essential employees, some businesses and business owners are giving them some type of a form that says, I'm an essential worker. This is why I'm driving. Should you be pulled over? So there is a guideline to keep a copy of that in your car as well, because it shows that you have a listing. And my understanding is that that should probably be done for each listing that you have.
Right.
That way, depending on where you're going, you have it for each listing posted in your car, on your website, everywhere. I think that's some of the guidelines.
Right. Okay, I see another question from Julie. She had she represents the seller. They were in contract. The only contingency involved was an inspection one. The buyer released that contingency on 3/26. Now, as I've discussed before, the buyer wants to back out due to losing money in the stock market. Are we required to let them out? Both parties signed the CVA on 3/24, but did not check boxes 2 and 3, which enables cancellation of the contract. Again, I would want to see the form, but in this instance, it seems more related to an unwillingness of the buyer to follow through. I don't know if the lender won't provide funding due to their stock market value as an individual. That's something I would want to find out. But this brings up an important issue I don't think I talked a lot about, and frankly, we don't see happen really ever. One remedy your client might have, and you're asking, do we have to let them out? The short answer is no. We have a remedy in law called specific performance, and I personally have not seen it been enforced, but I've heard that it has happened. It's a bit of a unicorn, and what the seller does is it sues the buyer and forces him to perform. And we've seen that question come up a lot from seller clients asking, can they do that? Again, it's difficult, but I do think that the argument has legs because there's risk for the seller to put the property back on the market right now because the market's so volatile and they might lose a bunch of value. So I know that's not really the answer you're looking for, Julie. It's not something that you can go to your clients with concrete information, but they're not forced to do anything. What they do need to do, if the buyer has clearly indicated that they're not going to close or they're going to cancel, is they do need to mitigate their damages. It's required under the law that the seller mitigate the harm caused by them by a buyer backing out. So if you do think that the buyer is not going to follow through, you might want to put the fishing line back out there, as we say, and start getting backup buyers, because eventually if the buyer does cancel, even if you keep their deposit, you have to mitigate. You can't just sit on the property. You have to try to limit the harm. And that goes back to the civil code section I mentioned, 1675, that allows buyers to basically monitor subsequent sales. And if you sell it for more the same price, they may have an argument for their deposit. So that's long-winded and complicated, but I would have your clients probably call us, call our firm, or email me, because I think they have some recourse there. It just, we would need a little bit more information and then try to see where we're at in the process. Let's see. Okay, from Doug, we talk about the order that in-persons are not allowed when the occupant is still residing in the residence. That's true. I've seen agents claim that if the seller were to leave for a few hours a day, for the weekend, or for a week, they can get around it. Yeah, I think you're right. It's not within the spirit of the order. Is there a time frame for which a seller were to vacate the property that would comply with the order? I don't know the answer to this one, and I would have to noodle on this and talk to my colleagues a little bit, but if I had my judge hat on, which I'm nowhere near experienced enough to do that, I would say relinquishing possession would be truly a vacancy, and this would be, handing over the keys as a tenant, or making it very clear that you've either abandoned the property or given up possession wherein you wouldn't be allowed back in, if that makes sense. So that's pretty drastic. Again, I would think that CAR would need to provide some guidance on that, and also the county, on how do you show these properties when almost all of them are going to have a seller inside. I mean, it's just kind of common sense that we would need some kind of guidance on this, because I think the exception to the situation is that the seller is not living there. Almost always they are, and so that is definitely a problem to deal with. And I see this as an issue coming up with disclosures down the road. If you can't adequately inspect the property or do your walkthrough inspection at the end of the transaction, does the buyer have a claim of non-disclosure or not being informed about the true condition of the property? So Doug, if you want to chat about this a little bit more, I will send you my email address right now, and we can try to nail that down if you'd like. So I'll send that. Let's see. So it seems like a lot of your guys' questions are related to conducting business, which rightfully so, since there is a lot of ambiguity in what you can and can't do. Let's see. Okay, CJ, this is a good question. Again, if you have multiple tenants in different properties, do you have to offer the same discount to all tenants? Again, each city and county, and even the state, has its own moratorium. So I would need to know where the properties are. Sounds like San Jose primarily. There isn't a requirement per se to offer a discount. What happens is if you don't receive rent for any given month, you can serve a 3-day notice. And with that, the tenant can reply with, hey, this is why I can't pay. They provide documentation, and, arguably they don't have to pay if they are able to prove it. But what I've seen happen, and what I've told landlord clients to do, is to try to work something out, work out a payment plan, work out a discounted rate. My mother-in-law is a landlord, and she offered a $500 discount to her tenant without being asked, because you rather receive a substantial portion of the rent than no rent. And so that's more of a practical pointer than it is procedural, because yes, you can serve notice and you will eventually get that rent, but would you rather wait 6 months or come to some kind of middle ground with the tenant and get money now? Again, you want to be careful with that, because if you do offer a discount, the one issue with that I see is that you don't want it to be a sliding scale. So you don't, yes, it's okay right now, but you want to have some kind of written language or written agreement between you and the tenant and saying this is only for the moratorium period. And once everything ends, you have to go back to your initial rent amount. A problem I see happening is that you agree to a discount and they just kind of stick to that for as long as they can. And so if you do want to do a discount, I would make it very specific that this is only for this period, and it doesn't extend past the shelter-in-place order or the moratorium date. Let's see. We answered most of these. Margie, good question. If you've seen the virtual tour, but it's not the same as seeing a property in person. Should you wait? If you can, yes, that's ideal. But again, if you have lending pre-approval or things putting pressure on your timing to buy the property, you might not have that luxury. I can't tell you how many disclosure cases I've had where either the buyers had tunnel vision and didn't really inspect the property like they should. They get sort of what I like to call buyer's goggles, or beer goggles as you may know them as, and you may look past certain flaws because they're in love with the property or whatever the case may be. They're in a rush. I could see that happening with the virtual showings, is that it's kind of like social media or whatever the case may be. You get only the best portion of the property. You might not see the mold shadowing in the bathroom or the cracks in the siding outside. I think there's an issue with the virtual tour because of the distribution. Who's controlling the tour? Who's distributing the information? Is it misguided? Is it are they hiding things? And so I think that's a big issue that will come up. And I could see us being in litigation saying, okay, well, did you really show the whole property? Why didn't you walk in this room? Or why didn't you show the ceiling? There was a leak there. You didn't show the roof. It has a ton of problems. So I think we're going to wrap up. I actually have a 3 p.m. But again, you all have my email address. You have Jody's contact information. If you have any other questions, please email me, reach out to our firm. We're still full systems will go, arguably busier than before just because of people don't know what the heck's going on, what to do. And it was my pleasure being here today. If you guys have specific topics that you want me to talk about or go over, come up, let me know. Yeah, let Jody know and we'll set it up for sure.
Yeah, I think just as a heads up, we're doing a landlord tenant very specific webinar. So I'd love, I'll be reaching out to you about that, and we'll get Ashlee on again as again, things are changing daily.
Yeah.
So thank you so much. And thank you to everybody who stayed on for a little bit longer.